Hello and welcome to the channel. If this is your first time here, please hit like, subscribe, and turn on notifications so you catch every new update without missing a beat. Let's walk through the specific legal tool that converted a trial defeat into this major financial challenge. The focus has shifted away from judicial interpretations alone. It now centers on a routine safeguard in the appeals process that has functioned precisely as intended, acting as an impartial check on claims. The key element is New York's established rule for posting an appeal bond. To see the full pressure on Trump, it's essential to understand exactly how this operates. After losing a civil case, a party choosing to appeal cannot just file papers and leave their assets unchanged. Courts recognize the risk that during a potentially years-long review, holdings could be transferred, diminished, or hidden. To address that concern, the law mandates a bond. This isn't a penalty or added cost. It functions as assurance. The appellant must obtain, generally from a specialized surety provider, a commitment that covers the complete judgment sum plus interest. That guarantee protects the prevailing party, making sure payment happens if the appeal does not succeed. The rule exists to maintain trust and equity in the process. For Trump, the figure involved was massive, around $450 million at the time. This is the point where courtroom strategy collided with undeniable financial constraints. Reports indicate his legal representatives reached out to more than 30 surety providers, the professionals whose daily work involves weighing risks, evaluating security, and determining feasibility. Virtually all declined to issue the bond, relying on his real estate portfolio as backing. Reflect on the significance. These entities operate without political bias. Their decisions stem from data, valuations, and calculated probabilities. A collective no from them represents an objective market assessment. It points to serious reservations, whether the assets fall short in confirmed worth to support such a large commitment, whether the odds of appeal success seem too uncertain, or a mix of those factors. This rejection from the business side inflicts damage comparable to the legal one because it remains free of any ideological slant. It boils down to pure economics, and the professionals found the terms unworkable. The case holds a remarkable twist. Attorney General Letitia James built her fraud action around accusations that Trump consistently overstated property values to lenders and insurers, gaining advantageous terms as a result. The trial court accepted the evidence and ruled that such misrepresentations happened repeatedly. Now, facing the need to use those exact holdings at elevated levels to meet the bond demand, the financial world has pushed back against accepting them at those figures. The reasoning forms a closed loop. The court determined the values were artificially boosted for benefit, and now neutral evaluators refuse to treat them as reliable for protection. Past practices have eroded the very credibility required in this moment. Ultimately, the appeal bond mechanism has operated as the clearest possible validator of financial position. It moves past rhetoric, defenses, and public framing to pose one straightforward question. Using documented assets and market standards, is this level of security achievable? The response, based on events, has been firmly negative. This step went further than confirming a verdict. It highlighted a fundamental exposure, transforming a paper judgment into real, pressing financial strain. Moving to the judge's written order that cleared the path for enforcement, it stands apart noticeably. This goes well beyond typical formal language. It presents a sharp, detailed critique that indicates a meaningful change in standing. Donald Trump has seen his reliability questioned directly in this venue. Judicial writing usually stays restrained and balanced. That restraint makes the chosen phrasing here especially forceful. The judge went beyond denying the motion to pause collection. He dismissed it outright, labeling the points raised as groundless and without legal support. In a particularly direct statement, he described certain assertions as undermining the court's own fairness and authority. Such wording appears infrequently in opinions. In the measured realm of court documents, it registers as strong disapproval. It echoes an authority figure not merely noting an error, but calling attention to a lack of respect for the proceedings. The ruling broke down each primary argument systematically. On claims of irreversible damage from immediate action, the notion that asset control now would inflict harm beyond appellate correction, the judge observed the clear connection. Any resulting issue traces back to noncompliance with the standard bond rule. That rule provided a direct means to prevent enforcement, and the difficulty in meeting it arises from decisions on that side. Concerning procedural fairness, the decision remained direct. New York's bond provision itself embodies standard due process. It weighs the opportunity to contest a ruling against the successful litigant's right to secure what was awarded. Pursuing an exemption here appeared to the court as a bid for favored treatment instead of uniform application. The section tackling allegations of political influence reached particular intensity. The judge addressed it squarely. He noted that frequent assertions of targeted persecution, raised whenever consequences arrive, have become repetitive and unsuitable for the setting. He stressed that depicting the complete New York legal apparatus, from the Attorney General to the judiciary, as part of a deliberate effort against one person lacks foundation in proof and harms the system's standing. The court affirmed that its conclusions derive from evidence presented, not outside pressures. This candid approach departs noticeably from conventional judicial caution. The departure sends a signal. This court perceives the approach more as a means of postponement, avoidance, and challenge to institutional norms than as earnest legal effort. By stating it plainly, the judge seems intent on keeping the courtroom focused on facts rather than political performance. That stance may guide handling in related matters, giving other judges a clear example for dealing firmly with similar patterns. It upholds that courts set limits and resist prolonged procedural tactics. Fundamentally, this episode captures a major clash between a long-cultivated public profile and rigorous outside evaluation. Donald Trump's persona, both in business and politics, has long depended on two linked themes: the portrayal of a highly accomplished, self-reliant entrepreneur and the image of an exceptional negotiator. Promoted across media, books, shows, and campaigns, the core idea was straightforward. Great wealth demonstrates sharp ability, consistent victory, and tangible proof through impressive holdings. Now, that carefully built narrative confronts a sharp contrast. Two independent, nonpartisan sources, the justice system and financial markets, have delivered converging assessments that question the central assertions. Attention has moved from celebrated transactions to enforcement actions and oversight appointments. Signature properties long showcased as triumphs, Trump Tower, 40 Wall Street, are undergoing cataloging, valuation, and potential state control. This amounts to a concrete, visible erosion of the symbols once held up as evidence of achievement. The impact reaches deeper than legal directives. The financial community's reluctance to back the assets at required levels quietly supports the court's view. Following the determination that values had been misrepresented for gain, those same holdings were presented in a standard commercial context. The inability to obtain support from any of over 30 qualified providers conveys a message from number-driven experts. Those figures do not withstand impartial review. That convergence between legal outcome and market judgment directly challenges the independent success storyline. It shifts the discussion from alleged bias to core reliability, revealing a significant divide between asserted riches and professionally verified circumstances. The active steps to enforce against Donald Trump's properties represent a critical shift, one that exposes the boundaries of a decades-old approach. In earlier disputes, business or legal, the pattern stayed consistent and often successful. Reject accusations completely, prolong matters through filings and challenges, redirect by alleging unfair targeting or institutional flaws. Victory rarely depended solely on merits. It aimed at draining opponents via duration, cost, and visibility until they compromised or retreated. That method worked against limited opponents. What emerges now is the end of that approach's viability. Routine efforts, urgent motions to block, appellate requests, claims of improper intent have faced repeated rejection. The court described core contentions as meritless. Options for halting enforcement through argument have narrowed sharply. The matter has entered full execution mode involving standard administrative actions, record review, property assessment, and asset protection by designated officials. This stage advances regardless of commentary, announcements, or additional filings. It resists being halted by recharacterization. Enforcement proceeds actively. The contrast with prior experiences appears clearly. Before, superior resources and tenacity frequently allowed prevailing over weaker parties. Here, the adversary is the government, backed by consistent funding, dedicated professionals, and a duty to uphold valid rulings. It lacks motivation to yield and cannot be exhausted. Its schedule aligns only with legal standards. Current enforcement illustrates that persistent delay strategies eventually confront an absolute limit, the state's capacity to implement judgments. In this setting, results have turned immediate, binding, and largely immune to past techniques. Looking broader, this situation tests an essential concept in practice, whether legal rules apply uniformly or if high profile and influence create exceptions to responsibility. The key issue isn't the original finding of fault. That stands resolved. The question is whether standard processes hold when the individual carries former presidential status and ongoing political activity. So far, the response points to affirmation, yes. The progression, trial, ruling, bond obligation, enforcement aligns exactly with what occurs in similar New York civil fraud actions. The bond acts as ordinary protection, not targeted measure. Collection follows when that protection goes unmet. The routine character of these steps, despite surrounding attention, defines the narrative. If procedures bent or stopped due to prominence, volume of claims, or assertions of injustice, it would create a troubling imbalance. It would indicate that visibility and insistence on mistreatment could suspend normal financial consequences. That kind of exception would damage trust in the system more profoundly than any one prosecution. It would suggest that standards for truthful dealings vary based on reach rather than facts. Politically, consequences turn on changing views. Legal issues have long been cast as vague, coordinated efforts, a view that connects with loyal groups. Tangible enforcement shifts the frame to real events. Rationalizing officials executing orders in familiar locations proves tougher than debating theories. For many, particularly swing observers, direct visuals outweigh arguments. The image of a proclaimed vast fortune undergoing seizure to meet a fraud obligation builds a strong counter-perspective. The outcome links back to prior choices. In summary, this stands as evidence that civil justice, methodical by nature and structured to withstand interference, can bear substantial force. Firm judicial statements, orderly enforcement, and market independence together show that framework enduring. Legal processes maintain their own pace and instruments distinct from political currents. The world observes whether the design functions as built, piece by piece, holding by holding. It continues to confirm that it does. Thank you for joining on this significant ongoing development. Enforcing a civil order against a former president holds wide-reaching legal, economic, and civic weight. We'll follow each step as events progress. From the team here, thanks for watching, keep connected, and see you next time.